What do you do after a DUI arrest to ensure that you can keep driving? Hi, my name is Evan Watson, and this is part of my video series for existing or current and new clients. Frequently, we talk about these things in our initial intake and follow up on them, but I always believe it's good to have something to refer back to. So, if you have been recently arrested for a DUI, chances are you got a form looking something like this. This is this 1205 suspension form. It is a Department of Driver Services form that you should have signed at the bottom, and it talks about temporary permits and your right to drive, as well as has some information about you and the arrest date, so on and so forth. On the back, it outlines, and this one doesn't have a back, but on the back it outlines the two different options you have. Either file an appeal for the suspension of your driver's license, that challenges the suspension, I should say, or go get an ignition interlock device. Now, you and I likely talked about which one's going to be best for you based upon your case-specific goals and how far you're willing to take your case. But again, for purposes of this video, I just want to reiterate the basics. This sheet of paper needs to be kept on you while you drive. It is technically, if you want to call it your license to drive, that would be correct. This sheet of paper does not limit what you can do or where you can drive. In other words, it's not a limited permit. It's simply your temporary license because, in effect, your plastic license was taken, and that one will be in law enforcement and then DDS hands. So keep this on you while you're driving, whether it's in a glove box, a purse, a wallet, or what have you. Second of all, what you need to know about the sheet of paper is there is now a 30-day window to do one of those two things, whether we're going to file an appeal for the suspension of your license or whether you're going to go get an ignition interlock device placed on your car. You have 30 days, and it's on the paper. There's still a ton of information circulating around that at this point is years old that talk about 10 days, 10 days, 10 days. And now don't even doubt there's still lawyers telling potential clients 10 days, but it is 30 days. If you do not do something within 30 days, on the 46th day, which is also mentioned on this form, your license would be suspended. But we're not going to let that happen. Let's be real. You hired us for a reason because we're good, competent lawyers and aren't going to let that happen. So again, keep it on you while you drive. Make sure you're aware of the timelines or that we're aware, and we discussed sending the appeal letter or getting your interlock within the 30 days. After that, we'll discuss in another video what happens at the administrative license suspension hearing, or we'll discuss if you opt for the 12-month ignition interlock option, what that's going to look like.